for admission. Item number 1.
This is the VP matter, na? VP matter. Okay. Yes. Yesterday, the government advocate was submitting. Yes, continue.
I'll continue from the on the first ground.
Mike.
On the ground that the detention order was passed mechanically without any application of mine. I raised my objection and I would like to read my counter affidavit. Page number 5, Your Lordship. I'll start from accordingly, Your Lordship. From the line, accordingly. Accordingly, the proposal substantiated by established facts and circumstances of the case was forwarded to the detaining authority. The FIR and the police report are valid documents containing the actual facts and circumstances of the case. The grounds of detention have been formulated by the detaining authority in line with the established facts and circumstances of the case. It is pertinent to mention that the detaining authority, while considering the detention of the detainee under the Act, had written letter such and such, dated such and such, to the sponsoring authority to ascertain the fact as to whether the accused person, namely Mr. Rodoko Lozitsu, has moved bail application in the competent court or already enlarged on bail as on date. A reply by letter such and such, dated 17/2/2023, in this regard was received from the sponsoring authority on 18/2/2023, informing that the detainee has not applied for bail till date. Having satisfied that the detainee was still under judicial custody in District Kohima, the Special Home Secretary passed the detention order dated 22/2/2023 against him. Accordingly, the fact that the detaining authority was aware that the detainee was in judicial custody at the time of passing the detention order dated 22/2/2023 is reflected in ground 4 of the grounds of detention communicated to the detainee. The detaining authority passed the detention order against the detainee after careful examination of the case and not on any flimsy ground. Your Lordship, I also like to read paragraph 8b. The averment made in ground 10 of the writ petition is denied by the answering respondent. The answering deponent states that as per record of this office, the representation dated 13/3/2023 was received by the detaining authority via India Post on 23/3/2023, as forwarded by the concerned jail authorities, which was put up for consideration of the detaining authority on 24/3/2023. The detaining authority, that is a special secretary home, carefully examined the points raised in the representation and having found no merit in the representation, turned it down. The detainee was accordingly informed by order dated 24/3/2023 against the representation dated 13/3/2023. Your Lordship, with regard to the query which the Learned Lordship had asked yesterday, Your Lordship, the detention order, the rejection of the detention order was passed after the case of the detainee was forwarded to the advisory board, Your Lordship. If I may read page number 7, Your Lordship. 8C, Your Lordship. The averment made in ground 10(3) of the writ petition is the submission of the petitioner. As per record of this office, the case of the detainee was forwarded to the PIDNTPS Advisory Board on 4/3/2023 for its independent examination, Your Lordship, and the rejection of the representation was on 24/3/2023, Your Lordship. And in support of this, Your Lordship, it's reported in 2020 16 SCC in Ankit Ashok Jalan versus Union of India and others, Your Lordship. Your Lordship, Lordship, in this judgment, Your Lordship, it is held that the state government is not bound to wait on the advisory board's report before deciding the representation and must do so as expeditiously as possible, Your Lordship. In this judgment. And Your Lordship, on the second round, Your Lordship,
Which para are you reading?
the reportable.
No, 2016 SSC. Which para? You have referred to this.
Your Lordship, unfortunately, I had got hold of this SEC copy only right now. I have the reportable copy with me. So,
The same judgment.
yes, Your Lordship. So if it is reportable, it's in paragraph 26, Your Lordship.
Who is that?
The same. Not the same. 26.
Yes, in the reportable, it's in 26, Your Lordship. Lordship, I'll give you the paragraph on this point, Your Lordship.
You actually satisfy us chronologically.
Yes, Your Lordship. So, Your Lordship, on the first ground, Your Lordship, when
Wait.
all.
Don't rush things, Miss Inauli. Don't rush things. Let us come back to this judgment, 2016. Which is that relevant? 26, you are saying? At least allow us to read.
Yes, Your Lordship. In the reportable judgment, it's.
Where is that reportable judgment? Oh my God. Keep it with him, with her. You're coming so casually to the court.
Your Lordship, I'll satisfy you later after.
Not later, now. You are emphasizing on a point and then you want to submit us, you want to satisfy us later. What is that submission you are making? See para 27?
Para 27, Your Lordship.
27.
Thus, if the law is now settled that a representation can be made to the specially empowered officer who has passed the order of the detention in accordance with the power vested in him, and the representation has to be independently considered by such detaining authority. The principal concern adverted in para 16 of the decision in K.M. Abdullah would not be the governing principle for such specially empowered officer. It must be stated that.
Are you in a hurry to attend some meeting or some program? Be slow.
It must be stated that the discussion in K.M. Abdullah Kunhi was purely in the context where the order of detention was passed by the appropriate government and not by the specially empowered officer. The principle laid down in said para 16 has therefore to be understood in the light of the subsequent decision rendered by another constitution bench in this court of Kamlesh Kumar. In the light of the opposite discussion, our answer to the first question is that the detaining authority ought to have considered the representation independently and without waiting for the report of the Central Advisory Board. Your Lordship. This is the para 28. And Your Lordship, with regard to the second ground, that there was no procedural that there on the submission of the petitioner that there was procedural lapses. Your Lordship, all procedural safeguards have been strictly adhered to, Your Lordship. If you may, Lordship, I would like you to take Your Lordship to.
Just para 27. Okay.
On the second ground that there has been a procedural lapses, Your Lordship, I object and state that all procedural safeguards have been strictly adhered to Your Lordship. Your Lordship, if you may, I would like to take you to the prevention of illicit traffic in narcotic drugs and psychotropic substances Act 1988, Your Lordship.
But this case is of Kofefosa.
NSA.
We have followed all the procedures prescribed in this Act, Your Lordship. Therefore, I would like to, Your Lordship, to take you to this Act, Your Lordship.
Only one. You are referring to NDPS.
Yes, Your Lordship.
Prevention.
It's in the NDPS Act, Your Lordship. Page number 103, Your Lordship.
Section.
Page,
You just tell us the section.
Section 3, Your Lordship.
Pages may be different.
Section 3, subsection 2, Your Lordship.
The 2016 edition. Okay. 10.
102.
This is PITNDPS Act.
103. This is on prevention. This illicit. This is prevention of illicit traffic use. 888. Okay.
Different.
Under this. Okay. Okay.
Your Lordship, Lordship has got it.
Yes.
Yes, I would like to read from section 3, Your Lordship. Powers to make orders detaining certain persons. The central government or a state government or any officer of the central government not below the rank of a joint secretary to the government, specially empowered for the purposes of this section by that government or any officer of a state not below the rank of a secretary to that government, specially empowered for the purposes of this section by that government may, if satisfied with respect to any person, including a foreigner, that with a view to preventing him from engaging in illicit traffic of narcotic drugs and psychotropic substances, it is necessary to do so, make an order directing that persons be detained. Subsection 2, Your Lordship. When any order of detention is made by the state government or by an officer empowered by the state government shall within 10 days forward to the central government a report in respect of the order, Your Lordship. Your Lordship, we had, in compliance of this section, Your Lordship, we had sent the report of detention to the central government on the same date, on 22/3/2023, Your Lordship. And it's in the record, Your Lordship. In compliance of this section, we have sent the report of the detention to the central government. And Your Lordship, I would also like to read section 3, subsection 3, Your Lordship. For the purposes of the clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention. Dear Lordship, we have complied within 6 days, Your Lordship. Due to general election, we have supplied the we had communicated to the detention of the detainee on 28 to 2023, Your Lordship, and it's in the record, Your Lordship. It should be not later than 5 days, and in exceptional cases, not later than 15 days, Lord. We have complied within 6 days, Your Lordship. And Your Lordship, I also like to read section 9, Your Lordship.
Communication when? 28.
Yes, on 28.
28 3.
28 to 2023
2 2.
to the detainee.
Okay. Report is to the central government on?
22nd 3 2023
Okay.
on the same day, Your Lordship.
And 28 is the communication.
Yes, to the detainee.
28 March.
28 February.
February.
Communication of the detention
Yes,
to the
yes.
detainee. That was done
But-
within 6 days. That is on 28 to
But-
2023.
This subsection 1. What about the detention order passed by whom? Special secretary. Should not be below the rank of secretary.
Yes, special secretary. It was
What
passed
do
by
you,
the
how do you
secretary.
justify? Special secretary is equivalent to secretary. See, reason is it a preventive detention.
Yes, Your Lordship.
Slightest violation.
Yes, Your Lordship, I understand.
Show us the special secretary is equal to the secretary. Not below the rank of
Below the
secretary.
rank of joint secretary, Your Lordship.
No, that is central government.
Central government, the state government.
State government is not below the rank of secretary.
Your Lordship, the special secretary is the secretary, Your Lordship.
Any officer of the state government.
Not below the rank of secretary, Your Lordship.
Has it been empowered? Has it been empowered?
Your Lordship, that I don't have any knowledge with regard to that, but it
Not
must-
below the
it
rank
must
of
have been-
requirement is not below the rank of secretary
Yes, Your
for
Lordship.
the state government,
Yes, Your Lordship.
which is specifically empowered.
Yes, Your Lordship.
That you have to show.
Your Lordship, here the special secretary is the head of the Home Department, Your Lordship. So automatically, Your Lordship, the
Not the head of the home department. You cannot say that he is actually maybe the head of a branch in the home department.
Yes,
Yes.
Your Lordship.
But you have to substantiate that. As Lordship has said, at least these are very technical, and unless there is some, when you are making that submission, I think you will have to support your submission with some orders.
Not only the secretary,
Yes, Your Lordship.
below the rank of secretary, but specifically he has to be empowered by the state.
Your Lordship, I'm sure there's some orders, Your Lordship, I may be allowed to produce.
Don't be
but
sure. Place it.
Yes, Your Lordship.
See, special, division bench has been constituted for this matter.
Yes, Your Lordship, I understand.
It's a preventive detention matter. You cannot take it lightly.
Your Lordship,
Invasion of personal liberty. Supreme Court is very heavy on it. You just cannot take it lightly.
Your Lordship, here I'm trying to satisfy on the points of delay, Your Lordship.
No, no.
Petitioner has,
You should prepare on all the grounds.
because yesterday the petitioner submitted two grounds. One for the,
But you just cannot evade the law, requirement of the law. You have
Yes,
read
Lord.
this. You have not read this. You are the one who has referred to the section 3.
I was specially referring to subsection 2, Your Lordship.
No, you just cannot read it in isolation. That
Yes,
is
Your
so
Lordship.
very
In
strange.
that aspect, Your Lordship, I'll satisfy Your Lordship.
Satisfied?
With an order, Your Lordship.
Huh?
With an order, Your Lordship, from instruction, Your Lordship, in the form of an instruction.
See, you cannot afford to let the people, language for a minute or two. The merit of the offense is, it is something different. So casual. You are representing the state. You are a government lawyer, public servant.
Can we give her the opportunity after two to give? After two? At two? You are writing if there is preventive detention, will be a person who can Yes, Learned Government Advocate, we are giving you time till 2 today. Till 2, you produce the order. That actually the special secretary is either equivalent to secretary or he is above the secretary. I think, if I'm not mistaken, the special secretary is manned by an IPS officer. And that IPS officer heads the police establishment branch in the Home Department. So you can immediately contact, I think you can contact the officer. Yes. Yes, and that order, whether he has been empowered. Okay. At 2. Because of this case, we have to sacrifice the other cases. But since this case we have heard yesterday, we are hearing today, and if you cannot produce, maybe by default, the government may lose. Yes. Okay, at 2. At 2.
item number 1. Next, please, my lord.
Yes.
My lord, if I simply say that the petitioner has been excommunicated by this native village by impugned notification dated 36/2023, perhaps it would be
Heard necessity, Amar. The learned counsel for the petitioner. Stop. The petitioners hails from Chongtia village under Mokokchung district. Stop. He is the unreturned candidate from the recently concluded general election to 14 NLA held in 2023 from 28 Koridong AC. Stop. The petitioner had earlier approached this court by filing WPC 237/2022, challenging the resolution number 2, dated 28/12/2021, adopted by Chongtia Citizen Forum, by which it was resolved that one Major B. Tushikawa Longchar shall be the consensus candidate from Chongtia village to contest the said election. Stop. The said WPC number so-and-so was disposed by this court by order dated 13/3/2023.
13/12/2022.
13/12/2022. Stop. Thereafter, on 16/2/2023, the respondent number 4 wrote the impugned letter to the petitioner, debarring him temporarily from the village. Stop. Again, the said respondent issued the impugned notification dated 36/2023, excommunicating the petitioner from Chungtia village for his lifetime. It is the case of the petitioner that the notification excommunicating the petitioner from the village is in clear violation of the constitutional and fundamental rights. Stop. Being aggrieved, the petitioner is before this court. Issue notice.
Lordship, there's a prayer for injury
Issue notice.
to state a notification as well as the impugned letter.
Issue notice to the respondents, returnable within 4 weeks. Stop. Ms. AIME represents the state respondent number 1, 2, and 3, and therefore no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state counsel in the course of the day.
Yes, Lordship.
In the course of the day, insofar as the respondent number 4, 5, 6, 7,
4 to 18, Lordship.
4 to 18 is concerned. The petitioner shall take steps. The learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
3 days, Lordship.
3 days. Stop.
If custody also can be permitted, Lordship.
As well as by dusty process.
Lordship.
Stop. In the interim, which is the impugned order?
There are 2, Lordship.
Yes.
One is impugned letter dated-
Page.
Next year, Lordship.
Page
Page 35.
35.
Yes. Translated copy is at page 36.
Okay, and the next 35.
Next is actual form at page 43. Translated copy is at page 44.
35. The first is at page 35, correct?
35. Translated is 36.
36. Okay, and the second one? The second one?
43, Lordship.
43.
Yes. Translated is at page 44.
Okay. Translate with. In the interim, the letter dated 16/2/2023, issued by which respondent?
Respondent number 4, Lordship.
Issued by respondent number 4. That is
Chongqing Village Council.
the Chungtia Village Council.
And it's the.
Just wait, just wait. Temporarily debarring the petitioner from being part of Chungtia village. And what is this? What do you call this? Notification?
Yes, Lordship.
Second one.
Yes, Lordship.
And Sangdongar.
Yes, Lordship.
That is notification.
I believe so, Lordship, because if it was information, then
And
they could have
and
answered.
and the notification. We didn't break it, okay, ma'am. SANGDONGER. Also issued by the respondent number 4.
Yes, Lordship.
That is Chungtia Village Council.
Which is signed by this
Just wait. Excommunicating the petitioner from Chungtia village, from Chungtia citizenship for his lifetime, shall remain suspended until further orders. Listed after 4 weeks.
Yes, Lordship. This is also important. It is also mentioned in the Sangdongar that any person who welcomes him within this village shall also, this or her house shall also be law.
Okay, it's all right. We have suspended that Sangdongar.
My Lord.
Okay.
Keep the order.
For motion, item number 2.
So who is for the government? Who is for the government?
Dia ang may malo.
KL?
Dia ang may
Kiangami.
important malo.
You are challenging a transfer order which was passed on 6 January 2023.
Yes, my lord.
You are still not transferred.
Yes, my lord.
Hari.
My lord, the Papua transfer order is issued to that petitioner, present petitioner, but he personal copy is not given to him. He inquired about for that matter, and he kind of know that his name is Constable Chopentan Lothar, and his regiment number is 419.
So what you mean to say is that the person whose name is mentioned in the order dated 6/1/2023 is not the petitioner.
Yes, my lord.
How?
He is-
Then why are you filing this case if you are not
Yes,
the
my lord,
petitioner?
he is agreed by this order, my lord.
When you are saying that this is not you, when you are saying that the person reflected in the order is not you, why are you filing this petition?
Yes, my lord, because the authority has insisted me to join in this service that wherever he-
That means that the order, the person mentioned in the order is you.
Yes, my lord. The is that one is by
This
the
is very confusing. Yes, before hearing this, I would like Mr. Nangami, you stand up. I think we need your service here. Yes, Mr. K. Angami is coming. Okay. Mr. K. Angami. See, you are actually handling this case.
Yes.
Yes, come to the petition. Let us see. Come to the petition. I want you to get instructions. Come to the petition, Annexure 16, page 16. Page 16. This transfer order dated 6/1/2023 is being challenged in this writ petition. The order was issued since January, and he continues to remain in the present posting. You need to get I think, a proper instruction on this, and then you come to page 6 of the petition. Yes. Para 8. Have you got it? Para 8, the second para. Let us read. Let us read. It is further submitted that the said order was issued in the name of CN Constable Poyo Penthang with regimental number 79143, which does not represent him as mentioned in the purported transfer and posting order. The petitioner's name is CN Poyo Penthang Lotha, and his regimental number is 71943. Therefore, the transfer and posting order issued to the petitioner is not related to him at all in any aspect. He is saying this order is not related to him. That's why I'm surprised why you are filing this case against this order. Get instruction? We'll list it on Monday.
I mean, allow me to suggest, he has a representation submitted.
No. You forget about his representation. He says that this order does not relate to him, whereas he is filing this writ petition against this order. So you get necessary instruction as to whether this order relates to him and why actually the order dated 6/1/2023 has not been acted upon till date if it relates to the petitioner. Get it on instruction on Monday. Listen again on Monday.
Lordship, in that case, Tuesday, Lordship.
My lord, on Monday though, I have a brain engagement for my personal problem.
No personal problem when you are being paid to represent the case. Okay, listen on Monday. Come with instruction.
Actually, I had to take my daughter to medical treatment. That is my problem.
Okay, so when can you make it?
Next Monday, my lord.
And if he is still not transferred, and if it is him, push him out. He cannot stay like this. When do you want it? Mr. Anguli, the learned counsel for the petitioner, submits that he has some personal difficulties today. He has some personal difficulties, and therefore the matter may be listed again on 7/8/2023. You get instruction, and if this order pertains to him, you inquire from the government as to why the government is sitting over this order since January. Okay.
For motion, item number 3.
Yes, Mr. Tongkok.
Yes, the lordship, in this case, petitioner is claiming the right for performing his duties in accordance with the rules. Like this is my case.
Okay.
In 2019, the CAG report related some excess travels by various officers of the state. Now, as per the central treasury rules, the petitioner cannot object or cannot refuse payment of bills coming before him, so long as it is signed by the authority concerned. So, subsequent to the detection, the AG also directed the government to recover the amount in accordance with the law. I wrote to the two officers who had withdrawn the money, the excess draw, to recover the amount. Then what happened in the meantime, the Lok Ayuktha conducted an inquiry. And based on the inquiry, I was asked to show cause as to why I should not be suspended. On the same day as that show cause notice was issued, I was suspension only, or I was divested of all the powers. And subsequently, again, on the basis of the subsequent report of the law Ayodhya, an Indian office memorandum has been issued as to why I should proposing to conduct inquiry, departmental inquiry against me. So, agreed by this, I have approached this honorable court.
Okay.
That is the crux of the case. Now,
Which are the impugn orders? Let us see. Which are the impugn orders?
the first order is come with the law of the order, which is 37.
Page?
37.
Yes.
If I may.
Yes.
So, this order is 15/11/2021. Under section 11(1) of the Nagaland Law Ayodhya Act 2017. The Nagaland Law Ayodhya has only preliminary inquiry into the pursuance of excess power by various departments of the state government based on the public report of the chief and deputy for the year ending 31st March 2019. The investigation so far has established the audit report of the chief and deputy accordingly to safeguard public revenue and to prevent further acts of misconduct of the public functionary. The Nagaland Law Ayodhya hereby forward its interim report to the competent authorities of the department and the inquiry with the following recommendation for immediate action within 30th November 2021. Number one, to take away the power of DPOs from the officers named in the law if they still are continuing to exercise the power of DPOs to their present post. Number two, to shift the staff named in the law from dealing with account measures to other ones of the office. Number three, to issue show cause notice to legal officers and staff named thereafter as to why they should not be put under suspension pending completion of inquiry investigation. Now, your lordship, the charges start from page 38. The page 39, the lordship, here the first period that is pertaining to STV of Walter. Here in column 4. The officer who report is instituted at STV of now retired. That's the one who is the STV of Walter. But on the next one, someone retired STV of Walter.
The petitioner, the petitioner is not the person who is mentioned in column 5. Lima Sangba. Okay, the second impugn order. Second impugn order. Yes, okay. We need not go into all those. Second impugn order.
Based on this, the second order is at page
Yes.
that copy is at page 52. So what is it? It means whereas it has been brought to the notice of the that the official listed in connection 1 who are serving on the graduates and accounts department have been named in the law for on involving in financial malpractice and the various government departments. Whereas the preliminary inquiry report suggests that this official, in connivance with other department officers and misappropriated government funds, now therefore, officials listed in Connection 1 are directed to show cause 2015 days from the date of issue of this order as to why they should not be put under suspension pending completion of inquiry and investigation. Connection 1, page 53, petitioner's name is action number 2. Senior graduate officer. And simultaneously on the same day, the next lecture H, your notice, page 54. This notification was issued, divesting him of all his duties. The tag copy is at page 54A. Next page. It refers to the order passed by the Honorable Upper Law Minister Navanet. The following Navanet duties of the account officer are divested of the required assignments and responsibilities given per the order. Serial number 1 is the petitioner. So simultaneously with the issuance of the show cause notice, this order has been issued. It has the same effect of suspension.
Next. Any other orders?
Order passed by the Navajo Law Minister. Paragraph 3 that copy is at the next 63A.
So this is clear. 63 is clear.
It is therefore determined that the finance department will become good on checking and tracking the bills for onward submission to the Homes to the interim action determinants of departments that impose minor penalties such as censure, administrative warning, runs on department that society will be sent departmental addition to the recovery action. Okay. The penalty should be uniform as provided in the knowledge service. Part 4, Rule 7.1 of the National Services, Disciplines and Appeals Rules 1967 as amended. Yes, a field officer of the department after which they may be restored back to their post and its responsibility. However, the graduate officers, accountants who have accumulated any grants for passing the bills that will reverse further penalty of either supervision 2 or 4 of Part 4, Rule 7.1 of the National Services, Discipline and Appeals Rules 1967 as amended. Thereafter, they may be restored back to their post and its responsibilities. So now, based on this, the next order, page 73. The finding follows from the next page, and according to this, the petitioner signs the bills without detecting that they are fake.
Any more impugn orders?
And the last machine order is at page 73. This, the clear copy is at page 24. This is annexure N. So this one, 74. 74 is the clear copy. Then memorandum. Then three. And the site proposes to order and inquire against the federal officer under Rule 9 of the National Service Procedure and Appeal Rules 9. Thus, the Honorable Superior of Banker to its order in 11/5/2022 on National Law Banker case number 10/11 of 2021 has recommended action against the Kishinumba based on inquiry conducted in the circular Model Access Program of various departments. 2. Sri Kishinumba directed to appear to submit within 10 days of the receipt of his memorandum a written statement of his defense and also to state whether he desires to be heard in person. 3. He is informed that an inquiry will be held only in respect of those articles on practice as are not admitted. He should therefore specifically admit or deny any article on ground. 4. Sri Kishinumba is further informed that if he does not submit a written statement of defense on or before the date specified in paragraph 1, or does not appear in person before an inquiry authority or otherwise fail or refuse to comply with the provisions of Rule 92 of the National Service Procedure and Appeal Rule 1967 of the Order Direction issued in pursuant of the state rule 1967 of the Order Direction issued in pursuant of the state rule. The inquiry authority can hold an inquiry against you next point. But attention of Sri Kishinumba is invited to Rule 20 of the National Government Servant Conduct Rules of 1967A, under which no government servant has been authorized to give any political or outside influence to bear upon any civilian authority to further his interest in respect of matters pertaining to the service under the government. If any representation is received on behalf of a higher person in respect of any matter to be heard in this article, it will be presumed that Sri Kishinumba is aware of that representation. In fact, it has been made as a concern and therefore action will be taken against him for violation of Rule 20 of the National Government Servant Conduct Rule 1968.
You are still not under suspension.
Still,
Here, I have made a statement concerning the provisions without. As on the rules, and paragraph 2 of the paragraph 2 of the rules. The functions and duties of regular officers are guided by the central regular rules. The rules in Australia makes clear provisions of regular officers to follow in matters relating to criminal appeals, coming from government officers. Rules 24, 27, 28, 1, 2, and 3, 128, 3, and 3, 1. These are pertinent to the action based on duties as follows. Regular officers may hide and physical inaccuracy or any obvious mistake in any given event is forbidden. I shall intimate to the government officer any correction which he makes. Rule 27. If a regular officer receives intimation from the accountant general that money has been encouraged to be drawn, and that a certain sum should be recovered from the government officer, he shall effect that recovery without delay and without regard to the corresponding undertaken or undertaken to a special request for. And the government officer shall without delay repay the sum in such manner as the accountant general may direct. 28 1. Subject as herein after provided in this rule, the procedure to be observed by a government officer in the department is called from the government account for expenditure from the regulated by the provisions made in this last part 4. The government officer shall write the funds for expenditure shall be responsible for such funds until an account of them has been rendered to the satisfaction
Why are you reading this provision?
Because this deals with the thrower officers. The one who throws the money is responsible for the funds withdrawn by.
You are not the drawal officer.
No. So now I just bring up the entire, then rule 138 is very clear. 138. When bills are accounted on accounts of charges incurred under any special order, the order sanctioning the charge to be voted, copies of sanction accompanying and bill must be duly certified by a executive officer or by a responsible subordinate authorized in his behalf by the head of the office. This provision does not authorize a treasury officer or any other disbursing officer to refuse payment of a bill on the ground that the charge has not been sanctioned. The responsibility for incurring unsanctioned charges rests with the zoning officer. It is very clear, the rules are very clear. The treasury officer cannot refuse payment. So, the only thing is that if
So far as that aspect is concerned, we will have to see the merit. What was your contribution? If you have any contribution in writing,
no filing aside,
we will see that. Heard Mr. Tongpok Pangoner, the Lieutenant Counsel for the petitioner. Stop. The petitioner is presently serving as Senior Treasury Officer, Mukokchung Treasury, Mukokchung Nagaland. Stop. The petitioner has filed the present petition impugning the following orders. Okay. Number 1, small Roman 1. The order dated 15/11/2021, passed by the learned Lokayukta, learned Upal Lokayukta. Recommending the following action against the petitioner. A, to take away the power of DDO from the officers named herein below if they are still continuing to exercise the power of DDO in their present post. B, to shift the staffs named herein below from dealing with accounts matters to other branch of the office. C, to show cause notice or to issue show cause notice to each of the officers and staffs named hereunder as to why they should not be put under suspension pending completion of inquiry/investigation. Number 2. 2. The show cause notice issued by the show cause notice, I'm sorry, dated 18/12/2021, issued by the Additional Chief Secretary and Finance Commissioner as to why the erring officials, which includes the petitioner, should not be put under suspension pending completion of inquiry/investigation. The notification dated 18/12/2021, issued by the Additional Chief Secretary and Finance Commissioner, divesting the petitioner of the current assignments and responsibilities till further orders. Correct? 3. Does your annexure, the next annexure L is regarding a censure, correct?
Censure, yes.
Censure. Then the next is 4, correct? The impugn order dated, don't say impugn, the order dated 11/5/2022, passed by the learned Upalokayukta, recommending disciplinary action of censure, CNSURE, against the petitioner and 5. The memorandum dated 3/3/2023, issued by the Additional Chief Secretary and Finance Commissioner, proposing to hold an inquiry against the petitioner under Rule 9 within bracket 2, clause 2 of the Nagaland Services, within bracket, Discipline and Appeal, close bracket, Rules 1967. Stop, new para. It is the case of the petitioner that the impugned notification slash show cause, etc., was issued by the authorities concerned without any proper justification in law. Stop. New para. Issue notice to the respondents, returnable within 4 weeks. Since MS Mary, the learned senior government advocate, represents the state respondents, no formal notice need be issued. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned state counsel within
2 days.
a period of 2 days from today, listed after 4 weeks. Okay.
Lordship, the interim prayer with regard to stay of the memorandum, at least may be considered.
Let the government get some instruction. The
The petitioner here is seeking leave against the Upai doctor is not a party, Your Lordship. Would it be?
yes.
Gopal Lok Ayuktha is a vote.
They have to be, because facing on death.
No. Upar Lok Ayukta is not a constitutional authority. Upar Lok Ayukta is only a statutory authority, and therefore, in all the cases which is passed by the Lok Ayukta, they are implemented as a party, and they are being represented. What is the exception in your case? I think you will have to implement. I think yes. I will not make a mention of anything. You think over it, because afterwards, if you are against the order passed by the Lok Ayukta, then we may not be able. This court may not be able to give any direction. So think over it. Think over it.
The interim prayer will be considered in the next.
Yes, we will at least. What was the last order, ma'am? What was the last line? Listed after 4 weeks, correct? Stop. The interim order shall be considered. No. The prayer for the interim order shall be considered on the next returnable date. You actually take care of that. Take care of that. That is very important.
Item number 4.
Yes. What is this?
Is that the petitioner is presently being promoted to
What is your main grievance? The petitioner is now serving us presently. Presently.
only recently he has been promoted to
That is Mr. Tongpok.
head assistant.
Before filing of the writ petition, he has been promoted. Before filing of the present writ petition. So presently he is serving as head assistant.
Head
Head assistant
So the advocate general Gauhati,
office.
Gauhati High Court.
Advocate General, Nagaland, correct?
Nagaland, yes. Nagaland, Gauhati High Court.
Just give me the gist
Yes.
as to why you are actually filing this writ petition.
This is that the petitioner was appointed in 1988.
So what is the no, I don't want to go through all those history. Just give me your case as to why you are aggrieved. You are now seeking in this petition, you are seeking for?
I am seeking for regularization of my UDA, to the post of UDA from the date of officiating. From the date I was.
Okay. Regularization
Yes.
from the date of,
Officiation as.
From the date of.
Officiating as UDA, which is 7/3/2006.
7/3/2006
Yes.
instead of?
Instead of from the date the order was issued, which was issued on it was issued on 27/9/2019. 27/9/2019, an impugned order was issued. As per prior to that, on 27/9 and 25/9/2019, the DPC was held. Now after the DPC, its officiating promotion is to be counted. But
So instead of the regularization, even from the date of,
its officiating,
no, you are seeking regularization from the date of your officiating promotion.
yes,
But the department has given you regularization from which date?
with effect from the date the order was issued, that is on 27/9/2009. And this is also contrary to the DPC.
Not with effect from the date of. When was the order issued? Giving you the
On 27/9/2019.
27 to
27/9.
27/9/2019. And what is the significance of this date, 27/9/2019?
Because,
This is what? This is DPC's recommendation or
no, on the basis of the DPC's recommendation, but contrary to the DPC's actual recommendation. The DPC on
no.
25,
Why actually the department has actually adopted this date, 27/9/2019? Why?
Your Lordship, there is no reasons given. The order simply says that it is officiating is from the date of issuance of the order. Your Lordship,
Oh. Just see that order. Let me see that order.
page 60, Your Lordship.
Page 60. Okay, it was so is regular from the date of the DPC.
From the date of the DPC, I'm sorry.
So from
The DPC was held on 25, which is
that is
Lecture D, page 59 is the DPC.
annexure 59.
Yes. D, page 59.
Page
59.
So, it's page 69. 69. Minus of the Departmental Promotion Committee meeting held on 25/9/2019 is page 69. Annexure P. Yeah, there's something wrong because from page 59, I think there is some inadvertent mistake. From page 59, it comes to page 69. You
I've done the presentation.
you make the correction. Why does this person not speak? Why? Who is he? Who is the person who is supposed to be attending the court? And why is he not here? Why is he not here? Who is supposed to take care of all this? You are. Who is the in charge? Who is the registrar, deputy registrar who is supposed to take care of all this? Call the court officer. Give him this. Call the court officer. Just wait, just wait. Where is your order dated 27/9?
Next page, sir.
And page 59, DPC. As recommended from which date?
From the date of the officiating promotion to the post of union.
Who is this again? Every time he is doing action from a secret, what is it? Must be, I forget it. Because every time he do it. Please tell him to be very punctual.
He got married, okay? Yeah.
effect from the date of officiating. So this was from the date of officiating promotion.
Yes. As per normal service laws.
But the order says regularized from the date of departmental promotion committee sitting.
Yes.
So sitting and recommendation is different.
Yes.
Sitting and recommendation, as per the department,
Yes.
25. And your regularization,
It should be from 2006.
the portion is 27/9. So the date of your regularization is effective from 27, 27/9/2019,
Yes.
from the date of this order. Effective from the date of this order. Okay, so you are actually against this order because you have been given a date effective from the date of this order, but not from the date of your officiating promotion in the year 2006.
That is one payment.
Okay.
Other payment.
The other,
It is based on the attachment of this honorable court in WBC 75 of 2017. Page 44. Answer J.
so to pay you scale pay.
Here they, yes.
Where is that notification? 18/7/2022.
That's page 85. Answer B.
Page 60. Which is this order? 18/7. Which page? So you are aggrieved by actually extending the pay band of 9,334 so and so with grade pay of 4,200.
Yes. It is not-
Your case is that you should be paid level 14 in the pay band of 15,600, 39,100 with grade pay of 5,700.
Yes,
That is your pay. That is your case.
that is my case. And in the affidavit which they filed in contempt petition.
No, we are not going in all this. That actually can be adjudicated during the merit. Whether your prayer is to quash and set aside the order
The
and this
first one-
notification.
The notification, Your Worship,
The, the order and the notification.
the order, my prayer is for.
What is your prayer list?
The impute portion regarding the base camp. My prayer is for. The notification, not the entire notification, but the impute portion.
Impugn portion.
Yes, with regard to the base camp.
Let's see your first one to set aside the impugn regularization
Yes,
order.
regularization order and
So if the regularization order is set aside, you will be reverted back to your temporary status.
and then to direct the state respondent to issue a fresh.
Mr. Tompok, you are a seasoned lawyer. You should know how to actually put these words. So how do we put it? Your relief. A.
Your Lordship since it has only to do with the regularization with effect from the earlier date of officiation, uh, in this case, even if it is set aside that a direction for granting him his officiating promotion from 2006 as is prayed for will be appropriate, Your Lordship. Because it is in the prayer, it is also mentioned to direct the respondent authority to regularize the petitioner from the date of his officiating promotion.
Third, Mr. Tongpok Pongola, the learned counsel for the petitioner. The present petition has been filed by the petitioner seeking for the following relief. Stop. One. Seeking for the following relief. To caution set aside. The order dated 27/9/2019, insofar as the date of regularization of the petitioner service is concerned. Stop. It is the case of the petitioner that his regularization and service should be from the date of his official promotion as UDA. That is 7/3/2006, correct?
Yes.
And not from the date of the passing of the order. That is 27/9/2019, correct? Yes. Two. Second one, okay? To set aside the notification dated 18/7/2022, insofar as the fee paid to the petitioner, in the fee band of rupees 9,300 dash 34 800 34,800, okay, with grade pay of rupees 4,200 PM is concerned. Stop. It is the case of the petitioner that it is the case of the petitioner. It is the case of the petitioner that he is entitled. To be paid the secretariat pay scale of level 14 in the pay band of rupees 15600 dash 39,100 with grade pay of rupees 5700. Correct? These are the two reliefs you are seeking.
Yes.
Okay. Issue notice to the respondents, returnable within 4 weeks. Since the Mr. E. Tipapong represents
All the respondents.
all the respondents, no formal notice need be issued to the said respondents. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the writ petition to the learned government advocate within
Today, in the course of
in the course of the day, listed after 4 weeks. Okay.
For admission, item number 5.
Yes. Are you ready? Mr. M.T. Longchar, kindly explain what is contingency employee.
Not contingent upon a certain situation. That is
Can you give me some citation?
Yes.
Can you give me some citation?
Not, I have to search. But the
I-
word meaning of contingent is till a regular process or what.
No, it cannot be. Contingent means still a regular process. That means if any person is appointed on contingency basis,
Yes.
then it means that he is assured of a regularization once the post is sanctioned. That cannot be. That cannot be.
Contingent upon, that is depending on the situation. That is the contingent.
Contingent means actually it's very uncertain.
Malo, that is a
It's
fact.
very uncertain.
Yes. In my case, the work is contingent, but it was continued, then promoted. When somebody is promoted, the moment somebody is promoted,
Do you have any citation on that?
Malot,
Because your case that is actually what is confusing the court.
Malot, that is in my. Malot, I have submitted the book list.
Book list, yes.
7/6/2022, Malot.
What is the citation?
Malot,
On this issue, on other issues, okay. On this issue, okay, we'll hear it after the listed matters. Other matters. We are hearing it, but kindly think over it, because unless you satisfy me on that issue, because I want to get satisfied, what is a contingency appointment?
Malot.
You were, because actually for the first 3-4 years you were on contingency basis,
Yes.
and that is why actually the government is saying that your contingency period of appointment should not be taken into consideration.
Malot, government have already rectified.
No, government, but the nodal officer, nodal department has said that you are not entitled. The commissioner must have rectified, deputy commissioner must have rectified, but the nodal officer, that is PNA department, is actually like taking a stand that you do not qualify the service, you do not qualify 10 years of service.
That undersecretary letter is against the memo issued by the chief secretary of PNA.
No. Again, there's an issue on that. Because
Yes.
actually, why I want to know what is contingency? Because that memo relates to ad hoc and contract.
Yes.
So whether you can say that contingency appointment is equal to ad hoc or contract.
Can it be taken up tomorrow? Because in Captain Singh, only contingency work charge in the light. It is given us
No.
in the
See,
light.
Jagjit Singh case.
Yes.
Jagjit Singh case clearly states that temporary employees includes ad hoc, work charge, contingency, all this.
My lord.
But my question here is, if you can kindly substantiate what is contingency approach. Because Jagjit Singh has also generally used the term contingency. It has not defined what is contingency.
No.
Ah.
But it is nomenclature is
So
contemporary.
I want to finish up your case, but that is where actually the stumbling block is.
My lord.
So if you can kindly, I think the Honorable Supreme Court or our own High Court, they must have actually defined what is contingency employee. They must have defined somewhere in some cases. Because I'm very sorry I could not get that.
Lordship, if I may be allowed to make
Uh,
a small submission.
Uh,
Where do we get the definition of the contingency or not, Your Lordship? Under the CCS pension rule, it is very clear that a person who is appointed on contingency, they are not entitled for any pensionary benefit.
Mr. Nizo,
Lordship.
I will also tell you what is that Prem Singh's case citation? What is that Prem Singh citation?
Prince Singh also
What is that citation? 2000?
10.
2010.
2019 10. My lord.
2019-10.
516.
You read that once. You read that one.
Running page 37 of my.
You read that once, because actually there, if I'm not mistaken, there it says that if the temporary employment
Lordship.
is continued as regular employment
Yes.
and that person is regularized,
Lordship.
the period of temporary appointment shall be counted for the purpose of pension.
Lordship, then I agree. But here is a case where the petitioner service has never been regularized.
My lord.
See, that's why I am saying that actually all this temporary, ad hoc, all this contingency, all these are fortuitous appointments.
Lordship.
Correct, fortuitous appointments.
Lordship.
So if in that fortuitous category, the petitioner has been enjoying the scale pay, has been treated as a regular employee, has been promoted, why his first appointment should not be counted for pension?
Yes, my lord.
So kindly read that Prem Singh's case and come.
My lord, I may be refer to that. Para 34. Services rendered even prior to regularization in the capacity of work charge employees, contingency paid fund employees, or non-pensionable staff placement shall also be counted towards the qualifying service, even if, my lord, such service is not preceded by temporary or regular appointment in a pensionable staff placement.
Is provided what? What is that condition given?
Shall be counted towards qualifying service even if such service is not preceded by temporary or regular appointment in a pensionable establishment. So just see that the contingency work.
Read further. I think there is some more which justifies that observation.
Malak Para 34 instead.
Then
What I understand is that services rendered prior to regularization in the capacity of work charge, contingency paid fund employees, or non-pensionable establishment shall also be counted towards the qualifying service, even if such service is not preceded by temporary or regular appointment in a just see that even if somebody was not regularized. In my case, I was promoted. Even if it is not preceded by temporary.
You were promoted because of the wrong ignorance of the deputy commissioner and all this. You were in contingency, you could not have been promoted. But you were promoted. Maybe the administrative officers, they were not well conversant with all this. So this is what is worrying me, because actually
Lordship, if that is the case, Lordship, can the matter be listed somewhere next week so that I will also go through some citations if I can find any.
Are you have not come with citation?
No, Lordship, not this morning, Lordship.
Come with citation.
Lordship.
And Mr. MP, please satisfy this court on your service as a contingency. You were appointed on contingency.
It is because of the nomenclature, madam. It is a sanction post in the scale of pay.
That is why, why,
Your Lordship has pointed out.
see, why don't you at least get some citation in support of your case? You were appointed on contingency basis, okay, against regular vacancy
In the scale of pay.
in the scale of pay.
Madam.
So if that is the case, then you should also be able to prove with law that your case was not contingency, but it was on regular basis.
My lord.
Because that actually, you were appointed on contingency against vacant posts in a scale of pay
In promoted.
and promoted with the question, the word vacancy used.
Lordship, to make the matter more complicated, though he was granted the scale of pay, Your Lordship, the petitioner was on a fixed pay for a period of 3 years in that contingency period, which is again mentioned in the service book, Your Lordship. And the petitioner in her representation also has admitted that. So in the order, though it was mentioned as scale of pay, the petitioner was never granted that scale of pay, but he was on a fixed pay for the three years of contingent period, Your Lordship. That is what is creating more.
My lord, can he take that stand now? My lord. I'm
No,
very-
it is not the government advocate who is taking that stand. That actually is mentioned in your service book.
Yes.
Service book.
One thing is that their own order can be attacked to it. No, it was rectified. No, it was paid in the scale of it.
What
By
were
their own.
what were you paid, Mr. MP?
No,
What were you paid? Were you paid fixed pay or scale pay?
My lord, that the disease. How it was paid? Because I'm not
No.
taking a stance even for knuckle and liver for period.
No.
Because the petitioner is too wide.
There's no
You do not the knowledge about that.
there's no dispute on that. There's no dispute on that. But actually, your appointment order shows that you were actually granted a scale of pay.
It's not me only, 16 of them. Okay.
No.
Appointment order is 16 of them.
Please don't drag in the other cases, because you have to prove your own case. So, what does the service rule says? Whether you were paid scale or you were paid fixed, that actually, I think there should be no dispute.
My lord, that has been rectified by the Office of the Deputy Commissioner. Now, this cannot be the issue because of shit.
Why not?
It's been rectified by the
No.
Deputy Commissioner.
Deputy Commissioner must have done something, but this court does not mean that it should go by what has been stated by the Deputy Commissioner. This court has to go by law. So we have to see whether your service rule shows that you were paid scale of pay or you were paid fixed pay. One may say so many things, but it is the record that speaks. Whether you have enclosed your service book.
My lord, It starts from page
What does the service? Let's see.
20.
We'll hear it on Tuesday, but let's see. Let me just.
Page 20 it starts in 21.
Page 20. Yes. 20. So page 20. Where does it say
Page
fixed pay?
21, my lord.
Page 21. Yes.
The next page.
But it is also not legible.
Lordship, if you see the middle sentence, it is contingency pay and pay in substantive post is rupees 100.
No, but Mr. N. Angami,
Lordship.
if you see the below, then appointed temporarily.
Yes, this is after he was given the temporary status.
Appointed temporarily.
So this is where I was wanting to
So
make
this
a
is after
correction.
promotion.
Yes, your lordship. And if you see the promotion order also, your lordship, it is clearly mentioned, if I may be allowed to show my lord, page 19, your lordship. Promotion order at page 19. Your lordship, it is clearly mentioned Sri Yalosya Sanctum contingency pay DB under the establishment of Deputy Commissioner is promoted and temporarily appointed to the post of grade 2. So the contingency service continuation from the initial date of appointment to this particular promotion orders carries. And therefore in the service book, it is mentioned that he was given the temporary status only from the date where he was given promotion and given the temporary status by this order 10 June 1974.
No, where have you shown me that fixed pay?
Fixed pay, Your Lordship.
This is not legible.
Yes,
Fixed pay plus special pay.
yes, Your Lordship.
Can any one of you get a?
My lord, let's take it that it's a fixed fee. I include this honorable court judgment order. In the case of Mamta Rani Rui, where they see that all service rendered by a fixed pay employee should be counted towards his or her qualifying service. This is a division page of Tripura,
Which year?
2016, volume 1, GLT, Tripura, 679. That is in the book list. Let's think it that this is was a fixed pay. Please,
If it is a fixed pay,
yes.
the notification issued by the central government will come into play.
My lord, the
Where only 50% of your fixed pay will be counted,
my lord, there is a
thereby making you
decision of
ineligible.
this honorable court, which is that it has to be counted. Or pension.
But the Supreme Court law is also very clear that just because somebody has to get a pension, it does not mean that it has to be paid in violation of the laws. You come prepared properly. I think I am still confused with this case. I'm still confused. Come with citation. Come with the Supreme Court citation, with the Honorable Division Bench citations and all this. Come and clear this case, because I think this is 2017. Huh?
My lord,
That is why I am trying my best to take up this case. But I am still in the wilderness on some issues. Some issues I am clear. But on some issues, especially on the issues which we are discussing, I am still a little hazy. Come with full citation, with full loss.
Lordship,
We'll list it on Tuesday.
Lordship, it can be on Thursday, Lordship.
Thursday,
I will-
it's not a very happy day for me. Oh.
some sufficient time will be granted to me, Lordship, so that I will try my best to get all those.
Okay, we'll list it on 8. 8, that is Tuesday.
Lordship.
Okay. Please come well prepared. Mr. Anangami,
Lordship.
you kindly give effort for at least 3-4 days continuous 24/7.
Lordship.
I just discussed. Mr. Imti also kindly assist, because I think we are too long on this case. And I think either right or wrong, I have to decide. I have to decide. But at least I want to decide with some definiteness. So kindly assist this court, okay?
Much.
Listed as a part heard on 8/8/2023. Okay?
Lordship.
Yes.
Did no best.
Yes.
For admission, item numbers 6 and 7.
Please, Your Lordship.
Yes.
My son has some personal difficulties today, so I pray this matter may come up after 2 weeks.
Okay.
Otherwise, pleadings are completed, so Your Lordship, because
Pleadings are completed. It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing, listed in the usual course. Okay.
Yes, Your Lordship.
For admission, item number 8.
Your Lordship.
Yes.
Your Lordship, I have an instruction from the petitioners here to withdraw the present petition, Your Lordship. So if Your Lordship can permit me to withdraw the deposit file fresh, Lordship.
MS so and so submits that she has instructions to withdraw the petition with liberty to file afresh. Stop. The petition is allowed to be withdrawn with liberty to file afresh.
Much pleasure.
For admission, item number 9.
This, Your Lordship.
Yes.
Your Lordship, here the pleadings are completed. They will be received.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be taken up for hearing. Stop. Listed for hearing in the usual course.
For admission, item number 10.
Please, Your Lordship.
Yes.
Lordship, I beg to make a mention on behalf of Council for Respondent 5, Mr. Y.P. Gupta. Since he is out of station, I pray that he said after 2 weeks.
Okay.
Yes.
Respondent number 5,
Yes, Lordship.
MS so-and-so, submits that Mr. Y.P. Gupta, the learned counsel for the respondent number 5, is out of station and therefore seeks adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks.
For admission, item number 11.
Yes, Lordship. Lordship, can you allow me 2 weeks time to Parliament to go to the affidavit of opposition filed by the
Mr. So-and-so, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
For admission, item number 12.
May I please, my lord? Also, we granted 2 weeks to file reply to the affidavit of opposition filed by the respondents.
Filed by union or
Respondents 1, 3, and 6, as well as 2, 4, and 5, they have filed separate
okay.
affidavits.
State is not a party. Mr. Senti Amr, the learned counsel for the petitioner, submits that he may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondents. Prayer is allowed, listed after 3 weeks.
What if there's an interim?
Stop. The interim order passed earlier shall continue till the next return.
Otherwise.
For admission, item number 13.
Lordship, in this matter, the pleadings are complete. Matter may be listed for hearing.
In the usual course, it is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed in the usual course.
The interim prayer may continue.
The interim prayer shall continue till the next returnable date.
For admission, item number 14.
This one.
Yes, Mr.
I agree for 2 weeks' time to.
Reply to the state. Affidavit filed by the state.
Yes.
Mr. Yamarwati, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time to file.
2 weeks' time.
He may be allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 3 weeks.
There's an interim also.
Okay, stop. The interim order passed earlier shall continue till the next reasonable date.
For admission, item numbers 15 to 55.
Yes. Any development? Any development? Item 15 to?
May it please your lordship.
Any development? Delhi?
Regarding the application about for this state,
Yes.
outcome of the case.
The case is over?
No, my lord, stay pending.
Oh, still pending. Yes, let us.
This one is picking up for 5 days. 8 days.
There are 2 cases, no? There are 2 cases.
Yes, my lord. One is from Nagaland State Government and one is from
Uh,
University. That one is it's on 8th of August.
8th of August.
Yes,
Your worship, that the answering respondent is taking every possible steps in support of the Chilean parties whose properties were damaged to the Ramadan campaign of excavated earth by the contractor, which is in contravention with the construction methodology. However, the matter is pending before the Honorable Delhi High Court for arbitral award. So we are not in a position today.
What is different cases? What is this? That bird bill. Mr. El, uh, Zatenmuli, the learned CGC. Places the copy of the order dated 6/11/2022, passed by the Honorable Delhi High Court in CKV. Please take note of this in, okay? No need to mention the party's name. And also the order dated 8/5/2023, passed by the State Court in Spencer, and submits that the present case, which is analogous to the case pending in the Delhi, which is analogous to the case pending in Delhi High Court, in the Honorable Delhi High Court, is yet to be disposed, and therefore submits that the present case may be listed after 3 weeks. The matter pending in the Supreme Court has been decided
Lordship,
in favor of the state.
Lordship.
What is that case? What is the title of that case? Nishevi,
Lordship, yes.
I think.
The instant petitioner and the petition is different. Lordship, here in my case, the petitioner is already on several occasions submitted representation.
That's all right. If you are not eligible, I think they may not have accepted.
Lordship,
And representation will not save the delay. You should have actually at least filed your case if you are eligible.
Lordship.
Okay. On the prayer made by the learned counsel for the parties, listed for hearing after 3 weeks.
Item number 57.
Your Lordship.
Yes, Miss Ayemi, why in a hurry to seek for adjournment?
Yes, Your Lordship. Your Lordship, earlier this matter was handled by my colleague, Ms. Pichano, and she has filed an affidavit on behalf of the state, where an inadvertent error has been made in paragraph 4, which totally changed the facts of the case. So if I might be allowed to file a fresh petition, affidavit, Your Lordship.
Additional affidavit?
Fresh affidavit in opposition, Your Lordship, because the previous one filed is totally wrong, Your Lordship. It changes the facts of the case.
You file an application for withdrawal of that. Okay, you file an application for withdrawal. I think that will be the right form. Okay, stating that because of these reasons, the state would like to withdraw the affidavit. Okay, and to file afresh. Okay, listed after, on the prayer of the learned government advocate, listed after a week. You come that week.
For addition, item number 58.
Your Lordship, on behalf of Senior Advocate Mohan, state is here to file affidavit, so kindly grant 3 weeks time.
Mr.
No
Sir,
objections, my lord.
what is the case, Mr. Cynthia R?
Actually, this is a dispute between the Smartphones and the listener.
Okay. So primarily, your case is your contest is between with Mr. Yangawati. Okay. So, well, give them time.
My lord.
You are mentioning on behalf of?
One, two.
Okay. MS. No. It's all right. It's all right. No names. The Learned Government Advocate. 6 for 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed. Listed after 2 weeks.
Let the interim continue, my lord.
Okay. Stop. The interim order passed earlier shall continue till the next returnable date.
Declare
Why then let it reflect in the constitution?
Okay. The name of Mr. Yangarwati, CGC, correct? CGC, shall be reflected as in the Delhi cause list.
declare bias.
For admission, item number 69.
Yes, what is this?
Lordship, this petition is in regards to the selection of village council.
Why IA?
Actually,
Mr. Yangarwati, why IA?
I don't get it.
Why IA?
Lordship, this is filed so that for praying for staying for the impugned appointment order by the date issued by the content number 2.
Okay. What is your ground? What is your ground?
Actually, the Lordship, this IA is filed so that his approval letter, impugned approval letter that has been issued by the
What is your ground for staying this?
so that
Who is leading you in the case?
beg your pardon,
Who is leading you in the case?
my senior.
Tell him to appear. Okay. Listed after a week.
For admission, item number 60.
Please, Your Lordship.
Yes.
Your Lordship, this file is recently handed over to me, and I feel that there's still some instruction that need to be sought. So 3 weeks may be granted, Your Lordship.
You have filed your affidavit?
No, Your Lordship, so far affidavit has not been filed, Your Lordship.
Why handing over, taking over?
Your Lordship, the Pichano is on maternity leave, Your Lordship.
Miss Devika, the Learned Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of these state respondents. Prayer is allowed. Listed after 3 weeks. Okay.
Your Lordship.
For admission, item number 61.
Yes, ma'am.
Your Lordship, I've just received the counter affidavit this morning. I've
Yeah.
gone through and I don't find it necessary to file a reply, Your Lordship.
Okay. So,
If it may be discussed after 2 weeks, or if Your Lordship allows me, it may be discussed
MS.
after.
MS. So and so. The Learned Counsel for the petitioner submits that she has received the copy of the affidavit filed by the state, and it will not be necessary to file the affidavit in reply. Stop. Pleadings are completed. Listed for hearing in the usual course. Okay.
Much obliged, ma'am.
Obliged.
For admission, item number 62.
Your Lordship. Your
Yes.
Lordship, on behalf of Moi Incheon, State has filed an appeal with regard to contingency regularization, writ appeal number 68 of 2021. This matter is related to that, so let the matter come up after disposal of writ appeal 68 of 2021.
Read appeal
68 of
in the division bench.
Yes, Your Lordship.
68.
Of
Read appeal
20
68/2021.
2021.
What is the subject matter?
Your Lordship,
The
Your Lordship, your petition is going for minimum scale of pay.
minimum scale of pay.
Yes, Your Lordship.
So the facts may be different. Let us see. Okay. Have you filed your affidavit? Have you filed your affidavit?
No, Your Lordship, State has not yet filed it.
Yes, you filed your affidavit. Okay. The state is granted 3 weeks' time to file affidavit. Listed after 3 weeks. Okay. You file affidavit.
For admission, item number 63.
May I please, my lord?
Yes.
Lordship, in this matter, I need to receive instruction from the department. If 3 weeks' time can kindly be granted to me, my lord.
Okay. Mr. A. Nangami, the Leonard Senior Government Advocate, submits that he is yet to receive instructions and therefore he may be granted further 3 weeks' time. Stop. Prayer is allowed. Listed after 3 weeks.
Deeply obliged, Your Lordship.
For admission, item number 64.
On behalf
Yes.
of Senior Advocate Moi Incheon,
Yes.
3 weeks' time may be granted to file affidavit.
Okay. The Leonard Government Advocate is granted 3 weeks' time to file affidavit in opposition. Listed after 3 weeks.
For admission, item number 65.
Yes.
Chief, can you grant me 3 weeks' time to file affidavit?
65 days. Yes, ma'am.
No, Chief.
Okay. What is your case?
Payment of completion at ground.
Okay. The Learning Government Advocate is granted 3 weeks' time to file affidavit in opposition. Stop. Prayer is allowed. Listed after 3 weeks.
For admission, item number 66.
This one, Lordship, I will
Yes.
allow 2 weeks to file my affidavit in reply to the affidavit opposition filed by the state respondents. They were filed in the month of May this year.
Okay. Mr. Sentianger, the Learning Counsel for the petitioner, is granted 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state. Listed after 3 weeks.
Deeply obliged.
Yes.
For admission, item number 67.
May I please, Your Lordship?
Yes.
Lordship, we are yet to file our affidavit in opposition,
You have for the respondent.
number 9. Further,
Respondent number
9.
9 and 10. Yeah, what about you?
State.
Yes, state, so what?
Yet to file. Since my 11 senior is in
Mr. So and so. Learned Counsel for the respondent number 9 and 10. Submits that he may be allowed 2 weeks' time,
2 weeks time.
3 weeks' time to file affidavit in opposition on behalf of the said SAID, okay, said respondents. Stop. The state also has similar prayer. Listed after 3 weeks.
Deeply obliged. Lordship, if the interim can continue.
Yes, the interim, stop. The interim order passed earlier shall continue till the next returnable date.
Much obliged.
For admission, item number 68.
May it please, my lord. Lordship, in the IA, I have filed an RTI. The department has already informed me to come and collect it, Lordship. So I will kindly grant it a few days, Lordship, 10
Okay.
days, Lordship. file appropriate affidavit.
Okay.
Yeah, yeah.
Mr. Santiyamar, the learned counsel for the applicant, submits that he may be allowed to take necessary steps. He may be allowed 3 weeks' time, 2 weeks' time, 2 weeks' time to take necessary steps in the application. Stop. Prayer is allowed, listed up to 2 weeks.
Keep your advice.
For admission, item, for others, item number 6.
This,
His Lordship.
ma'am, is this the order where I have actually passed that it should be?
Yes, Your Lordship.
Yes, Lordship, yes.
Two orders were passed on 18/7/2023. There are two different orders, Your Lordship.
See?
One order is
Seven?
not pertaining to our case, Your Lordship.
Wait, this people, they are not seeing this. Yes. The registry is accordingly directed to take steps as per the order dated 18/7/2023. Yes.
For hearing, item number 7.
Next question.
Yes.
Here, the present petitioner is a person with disability.
Uh,
The petitioner is equipped by the action of the Nagaland University
this is for hearing.
for hearing also.
Time may not permit us. Because at 2 again we have the division bench matter. We'll take up next Tuesday.
Next question.
Next Tuesday, okay? Due to paucity of time, list the matter again on. When is that? Next Tuesday? 8. 8. Or no. 2. Yes, first. List it again on 1. Correct? 1/8. Yes. Listed again on 8. Will 8 too? 1 is Changremong, na? That listed again on 8/8/2023. Okay.
For admission, item number 1.
Yes, ma'am.
First of all, I would like to express my gratitude for your patient hearing, Lordship. And as per the query, Lordship, I've producing a notification empowering the Special Secretary to, under this Act, Your Lordship, under the PNP.
Okay. Yes, the first part of the provision
Yes, sir.
that this special secretary is equivalent to secretary.
Your Lordship, verbally I've been informed that the Special Secretary is on par with the Secretary, Your Lordship. But, Your Lordship, it may be helpful, Your Lordship.
Yes.
This is the initial constitution of the Special Secretary to the post of Home Secretary, Home, Your Lordship.
Okay. Okay.
I wouldn't be, but I would use.
Okay. That is- Okay. Yes, continue, ma'am.
Yes, Your Lordship. On the ground that I followed all procedural safeguards, Your Lordship, I'd like Your Lordship to take to Your Lordship to Section 3, subsection 2, Your Lordship. When any order of detention.
Please wait. Allow us to at least open the page. Don't rush things. Section 3,
Subsection 2, Your Lordship.
section 3 of subsection 2 of section 3. Subsection,
Section 3, subsection 2, Your Lordship.
yes.
When any order of detention is made by a state government or by an officer empowered by a state government, the state government shall within 10 days forward to the central government a report in respect of the order, Your Lordship.
Yes.
In compliance with send this order, communication of the detention of the detained. Lordship. Oh, sorry, the report on the same day itself, Your Lordship. It is in report on 22nd to 2022, Your Lordship. We have sent the report of the detention to the central government within 10 days, Your Lordship. And Your Lordship, I also like to take subsection 3 now, Your Lordship. Sorry. Subsection 1 complies, subsection 2 complies, subsection 3, Your Lordship. For the purposes of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances, and for reasons to be recorded in writing, not later than 15 days from the date of detention. Your Lordship, in compliance of this section, Your Lordship, we've complied within 6 days, Your Lordship. Exceptional cases was due to general election, Your Lordship. The detention order was dated 22/2023. The communication to the detainee was given on 28/2/2023, Your Lordship. This was a delay of 1 day, Your Lordship. Exceptional cases were due to the general election which was held on 27th of February, Your Lordship. And I also like to take Your Lordship to section 9, Your Lordship. Advisory Board. For the purposes of subsection A of clause 4 and subclause C of clause 7 of Article 22 of the Constitution. I'd like to read subsection B, Your Lordship. Save and otherwise provided in section 10, the appropriate government shall within 5 weeks from the date of detention of a person under a detention order make a reference in respect thereof to the advisory board constituted under clause A to enable the advisory board to make the report under subclause A of clause 4 of Article 22 of the Constitution, Your Lordship. This was complied within 10 days, Your Lordship. 5 weeks is equal to 35 days. 35 days, reference has to be made to the advisory board. But we have complied it within 10 days. That is on 4/3/2023, Your Lordship. And Your Lordship, section 9, subsection 3, C, Your Lordship. The advisory board to which a reference is made under clause B shall, after considering the references and the materials placed before it, and after calling for such further information as it may deem necessary from the appropriate government or from any person called for the purpose through the appropriate government or from the person concerned, and if in any particular case it considers it essential so to do, or if the person concerned desires to be heard in person, after hearing him in person, prepare its report, such as specifying in a separate paragraph thereof its opinion as to whether or not there is sufficient cause for the detention of the person concerned, and submit the same within 11 weeks from the date of detention of the person concerned. So 11 weeks is equal to 77 days, Your Lordship. We have complied within 67 days, Your Lordship. Report was submitted on 1/5/2023, Your Lordship. So these are all the procedural safeguards which we have adhered to, Your Lordship. And as per the, with regard to representation, Your Lordship, the representation was received by the deponent on 23/3/2023, Your Lordship. And on the next day, that is 24/3/2023, the representation was considered and disposed, Your Lordship, which was rejected. The representation was rejected, and the same was delivered to the detainee on 28th, Your Lordship. Delay because the delay in sending the representation, the rejection of the representation to the detainee was because 24th was a Friday and 25th and 26th was Sunday. So on Monday we had sent a dark runner, Your Lordship, and this dark runner the letter reached the detainee on 28th, Your Lordship.
Confirmation order.
Rejection order of the rejection of the representation, Your Lordship,
By the
by the detaining authority, Your Lordship.
which date? 24 is
24. The date is 24/3/2023. This was the representation was rejected on this day, Your Lordship, and it was communicated. It reached the communication reached to the petitioner on 28th. That was Tuesday. There was 2 holidays in between, Saturday and Sunday. And Monday, they had sent the dark runner. Mahapur, Your Lordship. And therefore, Your Lordship, with regard to delay, Your Lordship, there has been no delay, Your Lordship, in disposing the representation, Your Lordship. And all procedural safeguards as required under this Act, under PIN DPS Act 1998, have been complied with and adhered to, Your Lordship. And Your Lordship, with regard to the subjective satisfaction, Your Lordship, I have already given the citation yesterday. Submitting today again.
What was the subjective satisfaction of the government?
The government, all the documents, Your Lordship, indicating the necessity, Your Lordship, to detain him, Your Lordship. It's on record, Your Lordship.
On record, what is your submission?
Your Lordship.
What is your submission? You submit as per the record.
Okay, Your Lordship. Your Lordship.
You first submit what was the subjective satisfaction, and then you support that submission of yours by the citation. So first, before you actually refer to the citation, you have to satisfy us as to what was the subjective satisfaction of detaining the detainee.
Your Lordship, the first ground I have already submitted yesterday, but just for reference, Your Lordship, the ground of the petitioner was that in the first ground, Your Lordship, they had made a statement that we had no knowledge that the detainee was in custody, Your Lordship. In fact, the grounds of detention, it was clearly mentioned that we had knowledge about his detention, but in order to prevent him from future prejudicial activities, we have detained him, Your Lordship. And everything is there in the detention order, Your Lordship.
Everything
And
means
if I-
what?
Your Lordship, if I may be allowed to read, Your Lordship.
Everything means what?
Yes, Your Lordship. In grounds of detention, Your Lordship.
No.
Lordship, the grounds of detention in the writ petition, Your Lordship. Page number 28, Your Lordship. I may be allowed to read.
Just wait, just wait.
Page number 28 of the writ petition.
This is your document. This is the government's document. Okay.
I would like to read from the just below the subject, Your Lordship. Whereas the undersigned has made detention order against you under the provision of the Prevention of Illicit Traffic and Narcotic Drugs and Psychotropic Substances Act 1988 on the following grounds. You, Mr. Rodokun Dulio Lizitsu, is both a consumer and trafficker of NDPS and has admitted to illegal trafficking and marketing of narcotic drugs and psychotropic substances in and around Kohima, conforming to acts under Section 2E of ITNDPS Act 1988, that you have been regularly procuring narcotic drugs from dealers in Senapati district, Manipur, and that you have been to Senapati more than 10 times, the latest being 14/1/2023, to purchase drugs with the intention to sell it to potential clients as evident in the material before me. That this reflects that you have knowingly engaged yourself in illicit traffic of narcotic drugs. That during the course of investigation, analysis of your call records and bank accounts and some suspected person from Senapati with whom you made financial transaction reveals the existence of vast intra and interstate network involved in smuggling and trafficking of illicit drugs, narcotics, and psychotropic substances. That you are presently under judicial custody with effect from 2/2/2023 on the basis of material placed before me. I am satisfied that you are likely to indulge in similar prejudicial activity unless you are prevented from doing so by an appropriate order of preventive detention. Taking into account the nature of your antecedent activities, it is likely that after your release from custody, you will indulge in prejudicial activities and it is necessary to detain you or to prevent you from engaging in such activities. The state of Nagaland lies within the area highly vulnerable to such illicit traffic of narcotic drugs and psychotropic substances. Therefore, keeping in view your propensity and inclination to indulge in such activities, it is necessary to detain you in order to prevent you from illicit traffic in narcotic drugs in future. In the light of the above facts and circumstances, I have no hesitation in arriving at the conclusion that Mr. Rodriguez Lesotho, through your above acts, engaged yourself in possession and transportation of narcotic drugs. Therefore, a fit case for detention under PITNDPS. Lordship, here I would like you to take to PINDPS Act 1988, Your Lordship. Your Lordship. Section 10, explanation 1, Your Lordship. Subsection 5, Your Lordship. This explains the inland area 100 kilometers.
Yes, wait. Which section?
Section 10.
Section 10.
Yes.
Cases in which and circumstances?
Yes, yes.
Section 10 starts with that word.
Yes, cases in which circumstances.
Okay, okay. So explanation 1.
Explanation 1, subsection 5, Your Lordship. Roman 5, Your Lordship. The inland area 100 kilometers is split from the India-Burma border in the states of Nagaland, of Arunachal Pradesh, Manipur, Mizoram, and Nagaland, Your Lordship.
The Indo-Burma border.
Senapati. Indo-Burma border.
Explanation 1. Explanation 1.
And below this.
Clause 4.
Five.
Clause 5. Clause 5.
Yes.
A, B, which one?
C, Your Lordship. Describes the area highly vulnerable to illicit traffic, Your Lordship. If I may be allowed to read from explanation 1, Your Lordship.
Yes, please.
In this subsection, area highly vulnerable to such illicit traffic means the inland area, I'm reading down subclause 5, Your Lordship. The inland area 100 kilometers in width from the India-Burma border in the state of Arunachal Pradesh, Manipur, Mizoram, and Nagaland, Your Lordship. So there was evidence of procuring drugs from Senapati, Your Lordship. And section 2E, Your Lordship, of PINDPS Act, Your Lordship.
Section
2E. His activities confirm the acts under section 2E, Your Lordship.
2E. Illicit traffic.
2E.
Yes.
Illicit traffic in relation to narcotic drugs and psychotropic substance means engaging in the production, manufacture, possession, sale, purchase, transportation, warehousing, concealment, use of consumption, import, interstate, export, interstate, import into India, export from India, or transshipment of narcotic drugs or psychotropic substances.
Section 2E.
Yes, Your Lordship, section 2E. Because his activities falls under this, Your Lordship. And Your Lordship, I would also...
So section 2E clause 3. Correct.
Yes. Lordship. Statement also, Your Lordship, but the petitioner has already annexed Caesar memo, Your Lordship. Your Lordship, page 18, Your Lordship.
Of?
I would like to, of the writ petition, Your Lordship. This is the Caesar memo, Your Lordship. Page 18 of the writ petition, Your Lordship. Your Lordship, I will.
Yes, yes.
10, Your Lordship. 10.
10.
Details of properties seized, recovered, use appropriate prescribed forms and attached. Pistol, .32, Thailand meth, 3, 2 number of vehicle key, pistol .22, one with 15 live rounds, or 2 diary, and just below that, mobile phone, iPod, Techno Black. Your Lordship. Your Lordship, I would also like to take your Lordship to the FIR, Your Lordship. Page 14, Your Lordship, of the resolution, Your Lordship. Page 14, if I may, Your Lordship.
Yes.
The officer in charge, to the officer in charge, Narcotic PS PHQ Nagaland Kohima. I have the honor to report that based on information from credible source that one Mr. Rodokoli Lezutsu, son of late Kevimese Lezutsu, residing below Chakasang Baptist Church, Kitsubuzo Colony, Kohima, Sardar, along with his associates, are involved in illegal trafficking of considerable quantity of narcotic drugs and psychotropic substances, and are also engaged in marketing the same to gullible people of Nagaland. And as per information received, Mr. Rodikulu Lezutsu has recruited several persons to trade in narcotic drugs and psychotropic substances in and around Kohima town. Further, it was informed that the suspect, Mr. Rodulu Lezutsu, is a member of one UG group. In this connection, as per the directive of the higher authority on 24/1/2023 at around 6 hours, a police party was organized, including STF, Narcotics Cell, and Crime Branch, and raid was conducted at the suspected accused residence located at Kitsubuzu, Kohima below Christian Revival Church, and he was apprehended and the following items were recovered from his bedroom were seized from his possession. Around 7 grams approximate of suspected heroin, cash amounting to rupees 10,100, few handmade pipes, apparatus used for consumption of drugs, 2 number of country-made pistol, .32 pistol and .22 pistol, along with 5 live round of .22 from his bedroom, along with item in seizure list. Further, basing on the information under the suspected person, female such and such, which acquaintance of the accused person was also apprehended from every colony. Therefore, I request you to register a case under the appropriate section of the law. Your Lordship.
But madam, your seizure list does not mention about the seizure of the psychotropic substance.
Yes, Your Lordship, in the records it's there, but I have not produced.
No, your seizure memo
Yes, Your Lordship.
does not mention about the seizure of a psychotropic substance.
Your Lordship, that is in the FIR, Your Lordship, it's mentioned.
No, in the FIR it's there.
Your Lordship, but if you see the records, it's there. I have not annexed in the affidavit. In the records, it's there. Whatever is mentioned in the FIR, it's there, Your Lordship.
File is contradictory.
One additional seizure list, Your Lordship.
Okay, where is
In
that?
there, it's there, Your Lordship.
In whose?
The record.
In the record.
Record is page. Record.
Page 77. Official file.
Okay, let us see the record. Okay. Yes, and madam, what is the relevancy of this 2013-4 SSC 531? The citation which you have placed?
Here, that we have no knowledge of this. The logic, my specific paragraph is 13, 14, and 17.
13,
which I
14.
underlined. 13, 14, and 17.
Yes.
With regard to bail, Your Lordship, the petitioner had alleged that we had no knowledge of the petitioner, whether the petitioner was out on bail or not. When in fact, I've also annexed my affidavit that with written letter to the jail authority seeking information whether he was under custody. And we had, on the next day, we had received information that he was under custody, but not taking the subjective satisfaction into account, Your Lordship, we had issued this preventive detention in order to detain him from future activities, Your Lordship, judicial activities involving in trafficking, Your Lordship. So, Your Lordship, relevant paragraph will be 13, 14, and 16 and 17, Your Lordship.
Read.
Lordship, I'd like to start from 15.
Yes, yes.
In a series of decisions, the court has held that effective satisfaction of the request has to be perpetrated in the detaining authority has narrated all the reasons for passing the detention order detaining the appellant with a view to prevent him from abetting the smuggling of goods in future. With regard to non-application of mine, Mr. K. Mani, learned counsel for the appellant, pointed out that the date of passing the detention order such and such the detainee was in prison, though he was granted bail on 12/4/2005, he had not availed the same as continued in prison on the date of the order. According to him, this aspect was not reflected in the detention order, which according to him vitiates the detention on the principle of non-application of mind. It is true that though the detainee was granted bail on such and such for the reasons based known to him, he did not avail such benefit and continued to be in jail on the date of the detention order. It is true that this aspect has not been mentioned in the detention order. However, on the other hand, it is not in dispute that the grounds of detention, which form part of the detention order, such and such, clearly mention the details about the bail order dated and non-availing of the same on the date of detention order, that is such and such. And 16, Your Lordship. Your Lordship, 17, Your Lordship. For the same reason, the other contention, namely that there is no compelling necessity to pass the order of detention, is to be rejected. As a matter of fact, the learned counsel for the detaining authority took us through various grounds, details, materials ever to the Union order, and we are satisfied that it cannot be claimed that there was no compelling necessity to pass the order of detention. We have already pointed out that it is the subjective satisfaction of the detaining authority whether the order of detention is to be invoked or not. Accordingly, we reject the above conclusion also. So, Your Lordship, with regard to the first ground, this is the citation, and regarding delay, Your Lordship, we're saying that there has been no delay, Your Lordship. And we have adhered to all the procedural safeguards as instructed in the Act, Your Lordship. We have followed the Act to the T, Your Lordship. That is my submission, Your Lordship. Your Lordship, and also the petitioner has a criminal background, Your Lordship. In the proposal, Your Lordship, proposal is in the
Okay, it's all right. We have heard you. Okay. Learned CGSC.
Lordship, I rely on one paragraph of my article. Because of the union.
Your affidavit. Affidavit on behalf of respondent number.
Respondent number 4.
Respondent number.
Small affidavit, Lordship. 4 page.
Who is that? Respondent number 4. You return this. Okay, okay.
The correct, Lordship.
Yes, please.
Lordship, I will go to para 3. I'll read just para 3.
Yes, please.
Lordship. That in reference to para 6, 9 of the petition and para 10, so and so of the grounds of petition, it is submitted that a representation dated 13/3/2003 was received by this ministry from the state government of Nagaland through post on 17/3/2023. Subsequently, the Parawai's comments on the representation were forwarded to this ministry by the state government through email dated 27/3/2023. The state government, via their email dated 29/3/2023,
had informed that the case of the tyranny was referred to the advisory board on 4/3/2023, and that the report of the advisory board was awaited. Accordingly, the matter was kept in abeyance as per the judgment of the Honorable Supreme Court of India dated 4/3/2020 in with petition criminal number 362/2019 titled Ankit Ashok Jalan versus Union of India, wherein Honorable Court has observed that the representations addressed to the central government would continue to be considered and disposed of either before a reference made to the advisory board or after the receipt of the advisory board opinion, and not during the pendency of the matter before the advisory board. Subsequently, the confirmation order dated 9/5/2023 issued by the state government was received in the ministry on 9/5/2023 by email. The said representation was examined along with the facts of the case and the relevant materials provided by the state government of district in Nagaland, we're going to say, and was submitted to the competent authority, that is the Secretary Revenue, on 10/5/2023, who, on behalf of the central government, carefully considered the material facts on record and disposed of the said representation by rejecting the same as duly conveyed to the petitioner through the jail authority concerned, White Barrington dated 16/5/2023, sent to the jail authority by email on 7/2023. So after the receipt of the representation through email, the central were further informed that the case has been forwarded to the advisory report. Now, as per the decision of the judgment, Honorable Judgment, Apex Court in Ankit Ashok Jalan case.
Where is that?
Here, the Red CCC is referring to Kofsa Egg, but in our case, it's NDP.
Okay, we will consider that, but let him first.
This 2020 GL, volume 16.
Yes.
First name before in the morning. In the morning.
2016.
2020, volume 16.
2000?
2020,
Volume?
16 SSC. 16 SSC.
What is the page?
Page is 127.
What is the relevant paragraph?
The relevant paragraph is page 163. This is page 162, Lordship. That is paragraph 14.8. And the relevant portion is at 163.
Yes, read.
Yes, page 163,
Ah.
the second paragraph, 16.
Ah.
We agree with the observation of Francis Gorali's case. The time imperative for consideration of representation can never be absolute or obsessive. It depends upon the necessities and the time at which the representation is made. The representation may be received before the case is referred to the advisory board, but there may not be time to dispose of the representation before referring the case to the advisory board. In that situation, the representation must also be forwarded to the advisory board along with the case of the tyranny. The representation may be received after the case of the tyranny is referred to the board. Even in this situation, the representation should be forwarded to the advisory board provided the board has not concluded the proceedings. In both the situations, there is no question of consideration of the representation before the receipt of the report of advisory board, nor it could be said that the government has delayed the consideration of the representation unnecessarily awaiting the report of the board. Next is very important. It is proper for the government in such situation to await the report of the board. So, as far as central government is concerned, we had awaited the report of the report, and on receipt of the report of the report, we had taken up the case on the same day. So there is no delay as such.
Yes.
Yes, Your Lordship. Because it is very clear that it is stated that it is proper for the government in such situation to await the report of the court. So only on receipt of the advisory report, on the same day we taken up the matter, and which was examined, and the destination was rejected. That is my own submission.
Okay, the petitioner, if you have any reply.
With regard to the judgment rendered by letter, this judgment is with regard to of side and not in PSA. As such, it's not relevant in this existing case. And with regard to the detaining authority, also, the detention order was passed by the Special Secretary to the Government of Nagaland, and the affidavit was filed by Special Secretary Home and not by the detaining authority.
What affidavit?
Affidavit to my criminal petition.
It has no relevance.
And also with regard to subject satisfaction, the detaining authority have already received a letter that I have never applied for bail and been satisfied they have passed the detention order. It's their statement. But they have to reflect in the detention order clearly in order to satisfy that no bail application is pending before court. However, in the near future, there is possibility that bail application may be filed and the detainee may be released. And in order to prevent that,
Where is the law on that?
uh,
Where is the law?
it's the subject of satisfaction.
No, where is the law? On your submission.
Yesterday I had placed one sentence.
Yes, go through it again.
Wadiram and C versus set of money.
Report it in. Report it in.
Criminal appeal number 840 of 2012.
By which court? Honorable Supreme Court.
Yes, Honorable Supreme Court.
Deborah Kashyap.
No. Wadiram Khanus Jao Singh
Babul Ahmed.
versus State of Manipur and others.
Petitioner. Oh, you got it?
You said that other one is corporate force. This is also NSA, not under the PAT NDPS.
Also, here the principle of
The same yardstick applies to
It
you.
applies to you.
Yes, let him complete. We'll hear you. We'll hear you. We'll give you sufficient time.
Para 9, supposed to. There was reliable material before the said authority, on the basis of which he could have reason to believe that there was real possibility of his release on bail. And further on being released, he would probably indulge in activities which are prejudicial to public order. And such statement has not been reflected in the detention order.
So we take into consideration both the rulings under NSA as well as Coffee Posa.
Lordship, either way, I have one ground.
No, this was on the facts of this case.
And even in
It's not a
Ankit,
universal
Lordship,
application.
even in Ankit, the facts is quite different.
Yes.
There were several representations.
That's why we'll not consider both the cases.
For delay of 66 days, in that case, I've dropped in disposing my representation.
This is observation is on the facts of this case.
Yes,
It is not a
the
universal.
facts is quite different. There
No,
were
no,
several
this case which you are
Yes, sir.
referring. Para 9.
Yes, sir.
In view of the above, it can be held that there is no prohibition in law. Your ground is there is no subjective satisfaction when passing the detention order. Number 2, there is a delay in representation either
There's a delay of 16 days in
by the
disposing
state,
my representation by the state government,
66
and
days.
66 days by the central government.
But somewhere you have said 65 in your petition.
Also, I think it's clerical error.
Huh?
Clerical error.
So which one, 65 or 66?
66, if you count the date.
Because 1 day delay is also matters. 66.
Yes, yes.
You have only 2 grounds. We'll record it 2 grounds only. No other grounds.
Yes, Miss Madam Inaholi, you are standing up again and again with anxiety. What is that?
Your Lordship, with the citation, Your Lordship, on which the petitioner is relying, Your Lordship. Here, I've also stated in my affidavit also, Your Lordship, but it's in the petition itself, Your Lordship, with page number 28, Your Lordship. In the detention order, grounds of detention, we have mentioned that in ground and paragraph 4, Your Lordship, we have mentioned that we were aware that he was in custody, Your Lordship.
We have seen it yesterday.
Okay.
Yesterday or
That
today.
point.
Yesterday and today. Yes. Heard heard Mr. Hisinlu, the learned counsel for the petitioner, MS Inaholi for the state respondents, and Mr. Yangawati, the learned CGC for the Union of India. Okay? Yes, keep it like that. We just want to know the names. We'll pass the judgment. Okay? We'll pass the judgment. Either today or tomorrow. Yes.